So the first thing that I want to say is that I'm actually quite relieved that you've taken the position that the principles set out in LCII apply ex nunc and not ex tunc, so that they will not apply to disputes that arose before the judgment was handed down. I suspect that the European Commission would have found otherwise, because if memory serves, in Motorola, despite acknowledging that the behavior in question, or that liability for the behavior in question was a novel theory, it still found liability and still concluded, despite not issuing a fine, that the conduct was an abuse of a dominant position. So I'm actually quite relieved at that. The other thing that I was actually going to, I'll change the order slightly of my observations, and to address one thing you said there at the very end, Peter, that the court was of the view that you would essentially take a quick look at the reasonableness of the offer made by the licensor, instead of having, let's call it, a full-fledged reasonableness or friend analysis. And I understand the reasons why you would want to do so, but at the by the same token, if that same quick look is used to consider whether the counteroffer made by the potential licensee is also reasonable, what you may very well have is, in case the court does conclude that it was reasonable, a situation where you would attach actually liability to the act of asking, of requesting an injunction on the basis of a quick look. Essentially, the judgment says that it creates a safe harbor for the licensor as long as it makes a friend offer, and the counter offer by the potential licensee is not friend. If you have a quick look at the offer made by the licensee, you conclude that it is friend, well, you'll be attaching liability. You'll be saying you have abuse of a dominant position, presumably or potentially on the basis of a very slim assessment. So that would just be my observation on whether the judgment requires a full-fledged friend analysis or whether a quick look is sufficient. I think one of the reasons, or the main reason this is the case, is because the Court of Justice essentially conflated two completely different issues in the ruling. On the one hand, question whether you should have antitrust liability. Say, you have abused dominant position, and the very different question of should a remedy, in this case an injunction, issue. And those are conceptually very, very different things. And there was no good reason to conflate them, except that the Court recognized that the Commission or the Union doesn't have the powers to regulate in this area, and so went down the antitrust path, which inevitably concludes with the attachment of liability. So I had 12 takeaways from the judgment, and they'll be very, very dry given the time allotted. I hope they're not controversial, but given this field, I'm sure they will be. So the first takeaway from the ruling is essentially, and this one should be incontroversial, that the Court of Justice has essentially created a novel type of abuse by attaching liability to a certain type of conduct which hitherto had not attracted antitrust liability under EU law, and that is asking for a certain remedy from the court, one that had been granted in certain circumstances, which was not necessarily granted, so it's a discretionary remedy. The second takeaway is that what the ruling does, in fact, is create a limited safe harbor for dominant SEP holders, and I will stress here dominant SEP holders who have given a friend commitment and who will comply with a procedure that is set out in the judgment, so with certain steps. So limited safe harbor for the owner of essential patents who is in a dominant position and who has given a friend commitment. It doesn't say anything about what happens when those circumstances are not satisfied. So the court does not determine how conduct that falls outside the safe harbor is or should be treated. It does not rule that a owner of essential patents who seeks an injunction outside that set of circumstances that is the court predefined would be abusing a dominant position. Nor does the court establish a general framework for the licensing of patents. It doesn't say this is how you should license standard essential patents. And it would apply erga omnes, and it applies to conduct consisting of asking the court for an injunction in certain circumstances. So the ruling cannot even apply to negotiations between owner of standard essential patents and potential licensee until such time as infringement proceedings are brought and an injunction is requested. The fifth takeaway is that the ruling requires the establishment of dominance. A holder of standard essential patents is not automatically dominant, although the court does not consider issues of market definition and dominance in the judgment itself, because it was not one of the questions asked of it by the Düsseldorf court. It does actually observe that both parties have equivalent bargaining power as holders of numerous SEPs, which suggests that neither is in a dominant position vis-a-vis the other. So one could even question whether the steps and the procedure, the methodology set out in the judgment would apply to the dispute underlying the referral. The sixth observation is that the ruling, in fact, requires that the SEPs in question be, one, valid, two, that they be actually essential, not merely patents that have been declared as potentially essential to an SSO, which would, in a way, require the court trying to apply it to do exactly the kind of work that Peter mentioned might perhaps be excessive at the time when it is confronted with the issue of whether the injunction should be granted or not. In other words, it presupposes the establishment of infringement, of validity. In Germany it's different, the court is not going to deal with that, but in other jurisdictions it will have, and essentiality. Not all patents that are declared as potentially essential are essential to a standard. The majority is not essential to a standard. And even patents that are actually essential to a standard may not be infringed by a standard compliant product for a whole host of reasons, including the fact that no one undertakes a conformity test to determine that a product which actually operates within, let's say, a phone in network makes use of the solution that is determined in the specifications for the standard. The seventh point is that the ruling implicitly rejects this whole idea of the willing licensee, or at the very least, how the notion of the willing licensee has been described in the Commission's Motorola and Samsung decision, as well as the Google MMI merger decision, which you will recall created a reversal of the burden of proof. Essentially, a essential patent holder who brings patent infringement proceedings, requests an injunction, would have effectively to show that the conduct was objectively justified by the unwillingness, amongst others, of the licensee. So you had a reversal. Now it appears to be clear from the judgment that we're not concerned with the notion of willing licensee, and that it will fall upon he who seeks to resist the injunction and who argues that will put forward a defense that the conduct is abusive, to actually prove that it is abusive. So the burden is on the implementer to show that the SEP holder's conduct is abusive. Now, the 10th observation or takeaway is that the ruling is remarkably silent on the controversial theories of hold-up, of royalty stacking, and on the notion of excessive or unreasonable royalties or exploitation by the patent holder, which was one of, if not the main justification for seeking to attach liability to that conduct. What was referred to in the Commission decisions as the imposition of disadvantageous licensing terms. Now, none of that is referred to despite the fact that the court was briefed on these questions, and rather the ruling talks about as the potential competitive harm or the theory of harm underpinning the attachment of liability in certain circumstances within this limited safe harbor to exclusion. And my reading of the judgment, therefore, is that it only applies to those SEP holders who actually compete downstream in a market for devices that comply with the standard. The potential anti-competitive effects described by the court are exclusionary. I'm looking here at paragraph 52 of the judgment, which says that the court is concerned that the SEP holder will prevent products manufactured by competitors, so competitors to the SEP holder, from appearing or remaining on the market, and thereby for the SEP holder to reserve to itself the manufacture of the products in question. So this is the classic leveraging theory, and one which is present throughout the case law, the limited case law of the Court of Justice on the intersection of IP and antitrust law, and it's worthy that one finds in the cases dealing with refusals to license, including IMSL. So I would contend that it does not apply to other circumstances where there's no incentive, perhaps there's no possibility for the owner of essential patent holders to exclude any rival, including perhaps because it is a pure licensor. It does not compete with the company, with the alleged infringer. And the last remark I had has to do with the omission in the ruling from any reference to the mere threat of an injunction. And you will recall that in the Commission decision and the debate around that time, the mere threat of the injunction was seen as sufficient to give rise to antitrust liability. Now, the court does not consider, it does not state, it makes no reference to potential anti-competitive effects that would result from the mere threat of an injunction. And so I wonder whether it could be possible for the SEP holder to avoid any risk, any exposure, any risk that it will be found to have abused a dominant position if it makes a request for an injunction conditional on a prior finding by the court that it has essentially complied with the steps in the judgment that created this limited safe harbor. It says, court, please find that company X has infringed my patents, and if you are satisfied that I have taken the steps provided for in the ruling, please award an injunction. And therefore, it would be conditional. I can see no reason why this could result, under the logic of the judgment, whether this could result in any form of abuse of a dominant position. And cognizant of the time, I will make a couple of other remarks, and I've been also asked to point out the main flaws. The main flaw of the judgment is that it is essentially at odds with basic principles of competition law, including those that have been set forth by the Commission itself in the horizontal cooperation guidelines. And I'll give you one example of this. In the horizontal cooperation guidelines, the Section 7 deals with standardization. The Commission recognizes that the assessment of whether a standardization agreement restricts competition, has anti-competitive effects, depends essentially on whether there is, on the question of access. And it also says that where there are several competing standards, or where effectively there is competition between standardized solutions and non-standardized solutions, a limitation of access may not produce restrictive effects on competition. So it recognizes that you have to examine the entire economic and legal context within which standard setting takes place, and if you're a judge, you have to examine the context in which patent infringement proceedings are brought. What you can't have is sweeping statements and broad assertions, such as the one that you find in paragraph 52 of the judgment, which tells you the following. Although the proprietor of the essential patent issue has the right to bring an action for a prohibitory injunction or for the recall of products, the fact that the patent has obtained standard essential patent status means that its proprietor can prevent products manufactured by competitors from appearing or remaining on the market and thereby reserve to itself the manufacture of the products in question, and that this is essentially an anti-competitive outcome, where it may very well not be the case. The mere fact that a patent is a standard essential patent does not necessarily mean that its owner will be able to have the type of competitive, anti-competitive, that its conduct may have the type of anti-competitive effect on the market, which the Commission itself considered in the guidelines as required in order to find a liability. And I think I will leave it at that.